Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong and I am your host. It is that time again. It is another opportunity to join The Community and the Law live on BWTV, where we bring you legal education and empowerment. This afternoon, I am going to ask a very interesting question. It's been on the minds of so many people. If you were with us last week, remember we looked at what the lawyer has to look for in the case when a client comes before them. This afternoon, I'm asking again, as a continuation, can a solicitor decline to represent someone? How do they do that, and why would they have to do that? Lawyer Charles Asma will be on hand again this afternoon on The Community and the Law to help us through that. Then apart from that, listen, sit back, relax, take notes, because there are some updates that are very important to your situation here in the UK. My name is Oreku Frimpong. Good afternoon once again, and welcome to The Community and the Law, brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome, welcome, welcome to the show. This is the Community Under Law and is brought to you by BWF Solicitors, our trusted partners when it comes to the law. We're looking this afternoon at a situation where you go before a lawyer, a solicitor, and the person says, listen, I can't take your case. Why? And if they have every good reason to decline taking your case, how are they going to do that? Lawyers are regulated by the authority here in the UK, and they go according to the dictates of what it is the regulations give them. BWF solicitors would want you to be in the known as to what those regulations are, what your expectation of every solicitor or lawyer is, and then what it is that they would have to do for you. Do they have the right to reject your case? Do they have the right to tell you that you are expected to do one, two, three, or four things so that your case is successful, or as it were, you do not have a good chance of succeeding? Do they have to do that? We will be getting into these things, and I believe that you will, at the end of the program, have some amount of knowledge within your repertoire to make sure that you are on the right hand side of the law. Once again, my name is Oreku Frimpon, and welcome to the Community and the Law. Now, let me tell you, BWF Solicitors is on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. You can reach them on telephone number 0208 493 7340. 0208 493 7340. Or in all situations, you can send a text, WhatsApp message, voice note, or even call 077 127 61884. 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. We've got some updates for you. We've got some questions for you. We've got some things and situations we need to celebrate. But first of all, welcome to July. January, February, March, April, May, June have all gone past. And we have started the second part of the year 2026. It looks like it's traveling quite quickly, isn't it? But you know what? A stitch in time, they say, saves nine. So whatever it is that we have to do, we need to get that done before it is too late. So on behalf of the BWF Solicitors family, I welcome you to the month of July 2026. May whatever it is that we have achieved be celebrated. Whatever it's ahead of us, may we have the strength and the desire to continue to achieve those. So, once again, on behalf of the senior partner and the lawyers, and the BWF Solicitors family, and everybody within the team, and on the behalf of BWTV, we want to welcome you to the month of July. Next, I have it's a little celebration, in fact, a massive celebration to be fair, because having worked throughout the month and being adjudged the Employee of the Month, June 2026, is a massive thing to celebrate. And that's going to our very own Pamela Oakley. Pamela is a trainee solicitor at BWF Solicitors. And you'd realize that in this year we've celebrated her, I think, a couple of times, and we want to say to her again, congratulations for winning another Employee of the Month in the year 2026. This one for the month of June, and we want to say, working alongside the senior partner, Pamela played a key role in supporting a complex, high-value, multi-asset and multi-party court civil litigation case. Through her meticulous preparation, organization, and dedication, she contributed to achieving a successful outcome for our client, including an award of costs. This recognition reflects her hard work, dedication, and the bright future ahead of her in the legal profession. So, BWF Solicitors would want to say congratulations to you, Pamela, for winning the Employee of the Month 2026. That is June 2026. Well done to you. Keep it going. And I believe, as the citation says, there is some wonderful piece of future ahead of you. So make sure you make it work like that for you. Next, I will want to really go on to some updates that we have. But before then, let me bring on Lawyer Charles Asmara, a resource person for this afternoon, coming from the stables of BWF Solicitors. Lawyer Charles Asma has a lot of knowledge, experience, and, of course, dedication to the community. So he makes time for us to help us understand what it is that the law says, unravel some of the mysteries we may have, and also take us through some strategies as to how we can navigate the route towards a successful application or resolving a legal issue. Loyasma, good afternoon once again.
Good afternoon, Brakoku.
Thank you very much for joining us and welcome to July.
Thank you.
Yeah. And I believe that um, let me put it this way: you have had some sleep to overcome the shock of Ghana getting out of the World Cup.
Yeah, I agree. But you see, when you know that everything in life is possible, you prepare for anything. So,
Mm.
yes, we were for we planned, and unfortunately, it didn't go the way we wanted. So, yeah, we've overcome the shock, and life goes on.
Well, life goes on, and we are in the community helping to empower them as we do usually. So, viewers, announce yourselves. Listen, we are live on Facebook and YouTube at BWF Solicitors and at BWTV UK. Lasma, before we move on, very own Pamela, as I think this is about the second time in the year 2026 that she's won Employee of the Month. And this one strikes some recognition and some acknowledgement higher than probably what we had previously. She had supported in a very big case, and through her dedication, being meticulous, and all that, there have been some great success to this. And for that, she's been voted Employee of the Month. It makes those of you senior in the roles feel good because somebody training to become one of you is excelling.
Yes, I agree. I agree with you. And well done to Pamela for um, going above and beyond, training hard and high, exceeding and achieving for the firm, for the community, and for herself. And we wish her well and expect to see more.
Mm.
Um, when you succeed in big legal cases, it tells you that you are developing the essential skills needed for meaningful legal practice. So great, great, great stuff, Pamela. I know you continue to excel. I wish you all the best. And this is just beginning of greater things to come.
Well, thank you very much for mentoring young people to become as great as you guys are. Well, moving on, last month there have been some developments within the week as to immigration reforms and the rest of it. There's one family life claims facing tougher rules that you put out earlier in the week, and we have it that the government has introduced the Border Security, Asylum, and Immigration Bill, proposing significant changes to how family life is considered in immigration cases if passed. This one says the bill will make it much harder for people who entered the UK illegally or remained here unlawfully to rely on relationships formed during the period, such as having a British partner or children. to resist removal or secure leave to remain. Importantly, it's talking about Article 8, I guess. Article 8 of the European Convention on Human Rights has not been abolished. Courts and the Home Office will still be required to consider such case on its own facts, including the best interests of any child. However, Parliament is proposing that much greater weight should be given to the public interest in maintaining effective immigration control, particularly where family life was established during unlawful residence. These reforms, I can agree, could have some significant impact on future human rights applications and appeals, and anyone affected, I know, as the advice has always been, should seek specialist legal advice before making an application. And for you at BWF Solicitors, I know this is what you would be standing for. So you support people. What is this talking about in real effect, lawyer?
Yes, so we know that Article 8 essentially is an entrenched right, a
Hmm.
protected right for people. Article 8 mainly is to do with your right to family life and your right to private life. The key bit here is when there is a clash between Article 8 right and protection of public interest. Where should the pendulum swing to? That appears to be an academic topic, but this is essentially what the bill is saying, that there are people with Article 8 rights whilst in the course of their illegal stay in the UK, they formed relationships, they became partners and parents, and and as a result of that, they acquired human rights under the European Convention on Human Rights and also the Human Rights Act 1998. You know that Human Rights Act 1998 is a derivative act from the European Convention on Human Rights, where the convention right or the convention obligations were supposed to be transposed into law by way of effecting the directive. And so the UK introduced the 1998 Human Rights Act, where most of the things covered under the European Convention on Human Rights were made into law for local consumption.
Hmm.
Now, we have European Convention on Human Rights, we have the Human Rights Act. They all protect human rights, including right to family life, be it a parent or a partner. We also have protection of public right or public interest, wherein offenders cannot be required to live in the UK
Hmm.
among the public. And so, where your character is not suitable, you cannot be allowed to remain in the UK. Question: I have a duty to leave so that my bad character does not affect the public good.
Hmm.
At the same time, the public has a duty to allow me to exercise my human right so that my human right cannot be affected.
Hmm.
Question: where there is a clash between duty to protect the public good and right to exercise human right clash, where should we tilt toward? And that is the bill. So the bill is simply saying that, you know what, if people have human right, it's good because it's an entrenched right or
Hmm.
protected right.
Right.
However, you cannot hide behind such rights against the good of the public. And so where somebody's behavior is so bad, then regardless of their rights as parents or partners in the UK, their Article 8 right will have to give way to their duty to protect the public good or interest. But
Right.
as is said, you can see from there that, well, it's an ongoing exercise, and the government, including Parliament, will have to do so much to ensure that people's rights are not taken away, and at the same time, the public interest is protected. So it's not a case that human rights will be taken away completely, but where human rights and public then duty to protect the public good or interest are weighed, where the weights are the same, then then the the public interest will go above Article 8 or human rights.
Mhm. Okay, so let's say, for instance, this person is being convicted of a criminal offense and has been giving the orders, so to speak, from the ordinary in the ordinary person's parlance, to leave the UK because the offense is against the community and so many other people. You can't say that I have human rights based on the Article 8 of the European Convention. I don't have to leave. Whatever it is, the law will go in favor of the greater community rather than the individual.
Exactly so. And it will be case by case basis, depending on the severity of that offense or issue or the risk to public.
Okay. So the proposal has been made. If we say if passed, so that it means that as we speak now, it is not law yet. Is that a proposal that has been more or less accepted?
Does it say it's a proposal or a bill?
Well, it says the bill, yes.
Yeah, bill. So the bill it's already been assented to by the king.
Okay.
Yeah, so it's a law. And as we go along, depends. So over the few months and years, you'll be seeing or having a lot of cases before the courts, and even the contemplation of whether the UK should continue to avail itself to the dictate of the European Convention on Human Rights. Remember
Mhm,
the European Convention. The question is Europe. Now, Europe is there, the wider Europe is there, and also the European Union is there. The
mhm,
European Convention on Human Rights um, is an act, it's an architecture. It's an architecture of the European laws and European Union rules themselves. Now that UK is out, I'm sure you've heard about a lot of people saying that we are out. So why do we still subscribe to matters
mhm.
or laws of UK, I mean EU?
You're the union, yes.
So over the period, I'm sure now that we've begun to see these things, let's give ourselves the next 5 years. It's possible that this European Convention on Human Rights, what have you, and all that will be put aside and will subscribe mainly to the Human Rights Act 1998. Because the Human Rights Act 1998 is a British law, and the European Convention on Human Rights is a EU-wide law. So the question is, if UK is part of the is part of Europe, but no longer part of the European Union. And so, why should somebody who has left the zone be susceptible to the dictates of the zone? And it's fair. So, unfortunately, that is where we are going. So, all of us should be mindful that if you think you have Article 8 right and therefore you misbehave, you get to a point where they say, you know what? Of course, you have Article 8. If your parents, if your family members so wish to be with you, they should follow you to the country where you are going.
If you just joined us, is live on the Community and the Law on BWTV, and we coming your way courtesy BWF Solicitors. At BWF Solicitors, cases are closely monitored. Progress of the bill that we just talked about will be monitored, and they will continue to provide updates on how these proposed changes may affect individuals and families. Contact BWF Solicitors 0208 493 7340. Or, yeah, as you have joined us, one, we encourage you to share the page and like it. And of course, leave your comments in the comment section down below at BWF Solicitors, both Facebook and YouTube, and at BWTV, both Facebook and YouTube. Now, another update we have, and Lawyer Asma will help us through that. We're talking about changes that are coming to settlement, that is indefinite leave to remain. And we're saying that if you're planning to settle in the UK, those proposed changes actually could affect you. Life in the UK test, we have higher English requirement, and then we will advise you as to what you should do when you find yourself in a situation like that. When we're talking about life in the UK test, the government has announced that plans to reform the test by moving away from historical facts and trivia towards a greater focus on British values, democracy, civic responsibility, and integration. There's also another update on the English requirement, which says that from March 26, 2027, most applicants for indefinite leave to remain will need to demonstrate English at CEFR level B2, replacing the current B1 requirement. Lasma, these changes, life in the UK test, is an interesting one because back in the day, they will ask you some historical dates, some events that happened, and the rest of it. What is coming up as these changes are being announced?
Right. So, I mean, we are told that British society evolved from history,
Hmm.
and over the years, because of diversity and other um, things that have featured strongly within the fabric of the British society, we've gone beyond the mere history and to look at integration, association, and cohesiveness. And
Hmm.
so, even I remember when I was teaching, anytime Ofsted came to inspect the school, for us as teachers, we're expected to be teaching the students British values. And
Right.
the British values are mainly value of democracy, the value of diversity, the value of teamwork, the value of responsibility, and so on and so forth. So we are now moving away from understanding the history to understanding how humans should coexist within the British society. And so the proposal is that going forward, the life in the UK test will not just be regurgitation of history and facts, but it's all going to be about British values. British values. So diversity. But of course, that's going to be intertwined because if you are talking about diversity, a question could be that, um, for example, I'm not going to give specific dates, but not too long ago, the 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 royal family availed itself to to sort of demonstrate one of the values within the British society, and by that they allowed one of the heirs to the throne to go beyond the status quo to marry a woman of his chosen or choice. What value is demonstrated here in this act or in this action? Is it value of responsibility? Is it British value of togetherness? Or British value of truthfulness? Or British value of diversity? Are you with me?
Yeah.
So here is diversity, isn't it?
Hmm.
Yes.
Inclusiveness as well.
Come again.
Inclusiveness as well.
Inclusiveness. Yeah, you see. So these are some of the questions that could be posed. I don't know, but for me, speaking as a teacher, a lecturer, I can foresee some of these questions if it's going to be hinged around British values, and I think that would be easier than the ones we had before, because the ones we had before it's history. If you don't
Hmm.
remember things like the War of the Roses, the Windsor family, the this, the that. and all the sovereignty, the supremacy, the ascension to the throne. Women were not part of it. Eventually, women became part of it when um, Prince William gave birth to a first child that is, for example, or a second child that was a female, and they wanted that female to have a right to the throne. The law was changed to accommodate that female right. All these things. So we are moving away from there.
Hmm.
Now you can apply it, it's functional, it's realistic, it's what happens day to day. And I believe it's a step in the right direction because if we are going to learn about British values beyond the classroom, then it will stem the tide on gun culture and all the vices that have become prevalent in our society here in Britain. And these are some of the things that the government want to move towards. So it's all going to be British values, British values, and how
Mm.
they help shape lives and culture in Britain.
I see some kind of relation between life in the UK and the English language requirement, where you'll be able to exist quite well and function properly within the British society. From 26th of March 2027, most applicants for indefinite leave to remain will need to demonstrate English at level B2, replacing the current level B1. I've often asked the question, and I want to ask again today. Why are they making it a bit more difficult?
Well, I mean, you talked about functionality.
Hmm.
You know, have you wondered why is it that every year phone companies come up with different functionalities at least twice a year or three times a year?
Hmm.
So if you look at Samsung phones, every year new one. iPhone, every year new one. Cars, every year new one. So it's all about the evolving nature of life.
Right.
And so if people could only read and write at basic level, and now we are at a computer age, AI age, where understanding and functioning within community and society goes beyond basic understanding and expression, then it's also important that the language itself will have to evolve to suit the level we are as far
Hmm.
as the time the trajectory of life is concerned. So now they are going to say, okay, if you want to be able to function in Britain, you should be able to express yourself by way of literacy at college level. What
Right.
happens at college level? Ability to write extensively, ability to understand extensively, and ability to express yourself extensively. So if you are attending interview beyond the basics, how do you function at that level? If you are asked to put data together, analyze some information to be able to show how you can function at work, it's that's English language. And therefore, if the language is changing, then we have to be able to move along in that respect. And that is why, because mind you, A1 is primary school basic level,
Hmm.
A2 is also primary school upper level. Primary school upper level is year 5 in year 6. If your child, after 20 years, is still able to express, read, and write at primary school level, then you say your child didn't survive as far as education is concerned, right?
Yeah.
Yeah, because they can't function. At this age, you are still expressing at primary school level. So we expect that you express at secondary school level, you express at college level, and you go on to express at degree or graduate level, depending on how far you've been. So even those who did not have the opportunity to go through formal education should be able to have the opportunity to express themselves at least college level. College level is B2.
Mm.
Ability to read, understand, and express beyond basic how are you? Where do you come from? I want to buy this. Where is my change? how much change you get, and so on and so forth, to be able to show directions. It goes beyond that, so that when you are asked to give testimony or witness to something, you'll be able to express yourself fully. And that is what
Okay.
the government is saying. And I believe it's not a bad idea. The only thing is that it affects most of our colleagues, or our most members within the community who have not had formal education. But even that, you can train yourself, because it is language. People are able
Yeah.
to understand Chinese language and write and read and write, French, read and write. So how much more if you really want to the English language? And so it is only going to be challenging at the initial stage, but over the period or years, people will get used to. But then there's going to be a way out for those who genuinely cannot meet that standard.
Okay. And I believe that those who are preparing for life in the UK test and the English language should continue to study the current test until the Home Office formally introduces any changes. And we're looking at March 2027. So if you think that you have some challenges with the new level, and you have an application to put in before then, please do it quite quickly and imminently, so that you take away yourself from that. And when it gets there, obviously, if you need help, you can also ask for help. Listen, if you need any further information on this one, please contact BWF Solicitors on 0208 493 7340 or 077 127 61884. It's still the community and the law. I know you remember and you know where we are operating from, and of course the platforms we're operating on. We on Facebook and YouTube at BWF Solicitors and at BWTV. Now let's pick up what it is that we transmit on and broadcast on. And when we come back, we will look at the nugget, which is also going to dovetail into our discussion this afternoon. Remember, when I give you the nugget, I give you the question, and we will be looking at what it is that you have to look for and how you empower yourself. Um, Okay, now let me do the third one just before we go, because at least this also has come up. The UK immigration data as we're showing, we're just showing you the very last one which we thought about. The Home Office has significantly tightened good character requirement. Past illegal entry or even overstaying could now result in your citizenship application being refused, despite having settled status or indefinite leave to remain. So, before submitting an application, make sure you understand how your immigration history could affect your eligibility. Good character requirement, 30th April 2026 is where we quoted this from. We take a break and take our social media handles, and when we come back, we'll pick up our nugget and start our discussion. Lawyer Charles Asma from BWF Solicitors is our
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
This is the community and the law is brought to you by BWF Solicitors, our trusted partners when it comes to the law. Every week at the beginning, we have a nugget coming your way, and we use that to test your knowledge into what it is that we're going to give you. Last week, we talked about the SRA, that is Solicitors Regulation Authority Code of Conduct for Solicitors, and we looked at one of them. This afternoon, we are looking at another one of that, and that's the Solicitors Regulation Authority Code of Conduct for Solicitors, paragraph 2.4. And it says explicitly, a solicitor must only make assertions or put forward statements, representations, or submissions to the court or others which are properly arguable. Properly arguable. I can put up something and say, well, my reasons are X, Y, and Z. Does it follow some steps, procedures, and criteria? And if so, what are those? Do I need to know? Yes, I think I do. So last one, what is paragraph 2.4 of the SRA Code of Conduct saying? You're mute, sir.
Okay, so the SRA is the Solicitors Regulation Authority in the UK.
Mm-hmm.
Their job is to regulate the conduct and practice of solicitors.
Right.
Now, we are officers of the law, and so our behaviors are regulated, what to do and what not to do. One of the points comes under the conduct paragraph 2.4. Paragraph 2.4 says that a solicitor must only make assertions or put forward statements or representations or submissions to the court or others which are properly arguable. What it means is that if the point we are making doesn't make sense or it defeats reasonableness, then it will be it will go against this provision 2.4. What is arguable point? An arguable point could be where somebody is applying to remain in the UK as a dependent of somebody who is um, who is a skilled worker. The skilled
Mhm.
worker became a skilled worker after the laws have changed. And the person, let's say it's on 6135, which is care workers. The person as a care worker, 6135, got the COS after 11th of March 2024. And at that point, the law said that family members cannot join unless the person was already a care worker. This person wasn't a care worker, and so family members cannot join. You are a lawyer, a solicitor. The person comes to you to say, lawyer, I want to apply. I want my dependent to be added to the application. I've just gotten my COS. Ordinarily, you go about argue human rights that he has a family or she has a family and blah, blah, blah. But this is not a human right application. This is a work-based application called point-based system specifics. And so
Mhm.
if you are going to argue Article 8 human rights, that will not be arguable, will it? No.
No.
Again, if you say that, don't worry, let's apply. So that because you have children, you have a wife or husband, we have to apply, even though the law doesn't permit it. Let's just push it. That is not arguable. And if it gets to the notice of, for example, SRA will be clear to say that the application or the representation or the argument you made were not arguable under the law. The specific law is appendix skilled worker, for example. And therefore, you are trying to push um, a square peg into a round hole with all the nice argument possible, but they don't fit. And therefore, it is not properly arguable. That's why the word is properly. It doesn't mean it is not arguable, but it cannot properly argue it out because
Mhm.
specifically the laws do not permit you to argue this way. Excuse me. So there are instances where we can argue, and there are
Mhm.
instances where the argument doesn't make sense. And where the argument doesn't make sense and you push it too hard, you can come under paragraph 2.4 of the SRA conduct provisions, which says that if it doesn't make sense, don't argue. And if you argue it, your behavior does not befit that of a solicitor.
Well, then let me pose this question. There's this scenario that somebody has. Hafiz joined his partner in the UK in 2023 as a dependent of a student. His partner completed her studies in December 2023 and he switched with her to a post study work visa in January 2024. Lawyer, before their post study work visa expired in 2026 January, he and his partner applied to switch to a skilled worker visa under Occupation Code 61364 Senior Carers. Counting down and going forward, in 2026 February, his partner was granted, but he was refused. The reason was that he does not meet the requirements for a skilled worker dependent as the rules had changed. He immediately applied for administrative review, which was decided on the 20th of June 2026 to maintain the refusal decision. Um, I'm tempted. Okay. Let me see. As my tradition would be, I would post this to the audience. But my question would be: would this be an arguable something? This lady wants his lawyer to challenge the refusal decision at judicial review, which means take it to court and let the court decide for us. Is it arguable? Properly arguable? Is it something we can properly present? Does it fall within the section 2.4 bit? I don't know. What do you think, lawyer?
Right. I mean, we will leave it for the community members to also share thoughts on
Mm.
this in the light
Okay.
of the nugget that enjoins solicitors to behave in certain manner.
Okay.
And at the end of the day, we'll pull all together and conclude on what the approach should be as
Should
far
be
as
okay.
this specific advice for this solicitor is concerned.
Well, the purpose of this program obviously is to empower the community so we can properly understand it, and the nugget that we are using this time around is also to help them understand and appreciate the position of solicitors, not to push them to do things that may not be in line with the regulations from the solicitors authority here in the UK. So viewers, family, think about that. I'm talking about this lady Hafiz who joined the partner. Hafiz who joined the partner, yes, in 2023 as a dependent of a student. This gentleman completed, no, the partner completed her studies in December 2023, and he switched with her to a post study work visa in January 2024. So look at December, January. Before their post study work visa expired in 2026 in January, he and his partner applied to switch to skilled worker visa under occupation code 6136. 6136 is for senior carers. A month later, the partner's visa was granted. Hafiz's lady visa was granted, or the status application was successful, but his was not, because the reason given was that it did not meet the requirements for a skilled worker dependent visa because the rules had changed. I am unpicking these ones so you can situate it so quite well and give me a good answer. He then applied for administrative review, and in June 2026, they came back to say, nah, we did not make a mistake. You cannot be granted that. Now, this gentleman has gone to a solicitor and said to the solicitor, listen, go and challenge this in court for me because I think they are wrong. So the law should be on my side. If the solicitor was your friend, if the solicitor was your partner, if the solicitor was your family member, or the solicitor says, what do you think in the view of regulation 2 or the paragraph 2.4 of our regulations? What do you think I should do? Think about that and give me an answer later on. But that dovetails us into our topic this afternoon, ladies and gentlemen, and I'm going to ask Lawyer Asma to help us answer this question. In fact, two questions in one. Can a solicitor decline to represent someone? You go before them. I go before Lawyer Charles Asma and I say to him, I have this case so complicated. I know you so well educated, you so meticulous about that, you know the law and all the rest of it. The lawyer says, no, I can't take this case. Can he do that? If he can, how? And why is it that he cannot? This is what we are going to look at. So, Lawyer Asma, I've come before you. Can you decline to represent me? If so, why and why and how are you going to do that?
Sure. Yes, thank you so much. Bakweku, did you show the I'm not sure whether I saw it properly. You showed
Mm.
something, and I said that the public will judge on that, right? Or that we
Mhm.
give them opportunity. Was that a question? Was that a problem question thing, or it was another thing?
Yeah, so this was a situation where this Hafiz guy that I'm talking about, his situation, and he's gone before a lawyer, asking the lawyer to do that, to do a judicial review for him.
Oh no! I'm talking about before that. Did you show after the first nugget? Did you show another nugget?
There was this immigration about character that we showed.
Oh, okay. Then
I don't know
let's
whether we would.
yeah, let's echo that. Let's echo that.
Okay, okay.
Yeah. So yeah, okay, yeah, okay. This one, okay, okay. Let's echo that. So please, help.
Well,
Yeah,
I'll read that quickly for you
yeah.
to unravel that and explain it a bit further for us, if that's okay. And it talks about Home Office has significantly tightened the good character requirement. A past illegal entry or even overstaying could now result in your citizenship application being refused despite having settled status or indefinite leave to remain. So before submitting an application, make sure you understand how immigration history could affect your eligibility. And I mentioned that we picked that from a good character requirement that was brought into the Nationality Act and dated 30th of April 2026. Yes, Laura, you wanted to help us with this.
All right. Yeah. So the good character assessment, and we know that if your character is not conducive to the public good, it will be difficult for you, and that also dovetails into the bill that has been passed. That excuse me, if you have Article 8 right, it doesn't mean that if your character is bad, you will still be considered to remain in the UK. So
Hmm.
it's to do with good character assessment. And the assessment is really, really rigorous now. And as we can see from here, um, before submitting an application, of course, you have to make sure that if there are issues about past behavior, criminal conduct, anything like that, you have explored the argument properly to be able to mitigate whatever effect this may be on your indefinite leave to remain or naturalization application. So don't just make an application simply because you qualify. Make application bearing in mind that your character could be picked up, and so you address it in the application as you submit.
All right. So, yeah, and I would keep advising that if you need further clarification on this, you can call BWF Solicitors 0208-493-7340 or 077-127-61884. And if you have any question, you can text 07399-208-468. Whilst we're on the program, the community and the law, you can leave that in the comment section down below. Facebook at BWF Solicitors, YouTube at BWF Solicitors, and of course, BWTV on both platforms. Yes, lawyer. My question again. I come to you, Lasma. I believe you. I trust you. You do so very well. When it comes on the community and the law, you educate us quite well. You take us through the steps and the strategies to do that. So this is my case. Would you have any reason to say that I won't take this case? How are you going to do that, and why would you want to do that?
Right. So, as I said, everything we do as solicitors must be fully guided by the ethos of our profession. And so, we are
Hmm.
going to look at what the rules say, the ones that apply to what we do with clients, and also what to do when confronted with this. Here, we are looking at before starting and after you have taken over or after you have started, what can you do if some things come to light?
Hmm.
So before you start, it's all about the knowledge and understanding because you have to give the client advice.
All right.
If the client is not clear or able to disclose certain facts to you, and later on the facts become clearer to you, you still have a duty to ensure that you comply with the rules. And so, even if you didn't know and you became aware, what does the rule say? So, we are looking at the Solicitors Regulation Authority rules of conduct and also the principles that we have to follow as solicitors. We have one principle that we are going to explore when taking cases and during the time the case has started, or while after the case has started, whether to continue or not. The other, then we'll go to the conduct, what the solicitor will view our conduct to be, whether within the scope or outside the scope. If it is within the scope, it means we are okay. If it is outside the scope, it means we have gone beyond the boundaries required and we have to be able to answer for it. So we will ask producer to help us with the rule book for solicitors. So, Braco, we are going to help. I will start with the principles, and after that, we'll look at the conduct matters. So, if
Mm.
we go to producer, scroll down, let's see if they are there. Okay, principles, good. So, we'll look at the principle, then after that, we'll come to the code of conduct. Yeah, so the principle. Let's go to principle number 7. Number
Well,
7.
principle number 7 says that in the best interest of each client,
Okay, so
in the
click,
best
click on
interest.
that.
So the client has a hyperlink which will take us to another page, or then it explains the term. And
Exactly.
this one says means the person for whom you act and where the context permits includes prospective and former clients. In the SRE financial services, that is scopes and rules in relation to any regulated financial services activities carried on by an authorized body for a trust or the estate of a deceased person, including a controlled trust, means the trustees or personal representatives in their capacity as such, and not any person who is a beneficiary under the
No,
trust.
I think producer, I think you selected client only. You didn't look at the number 7 itself. Where is the explanation for number 7? Does it, so select 7. Let me see if that will open 7. Number 7. If you click on number 7, will it open? Scroll down, let's see, please. If the full level,
No,
it's
that's
not there.
not
But
it.
okay, that's it. Okay, so it says acting in the best interest of client. Client means anybody who comes to us. Now, acting in their best interest simply means that whatever we do should be to benefit that person.
Okay.
I yeah, whatever we do should be to benefit that person. So, for instance, if somebody comes to us or to me to say that this is what I want to do, I will check whether in the large scheme of things or on a balance of probabilities, it will serve the purpose for the client. There are instances you have to push and push harder, and there are instances where you you have to be bold and frank enough to tell the client that this will really not serve you any good or purpose.
Mhm.
And that is not wrong because we are supposed to ensure that we act with the best of integrity. That means opening up to the client. So if it is not going to be in the best interest of the client, then you don't have to act for that client. So so we are looking at where you have to decline, and that is why this is important. If it is not in the best interest of the client, you have to say, I'm sorry, I cannot do this for you. That is one bit. And we are going to look at examples as we start the conversation.
Okay.
I'll move on to the next stage of the conversation. Now, let's look at the conduct, the conduct as well. Conduct, if you go back here, conduct matters. Yeah. Yeah, so scroll down. Go to number 2. Yeah, what does number 2 say?
Dispute resolutions and proceedings before courts, tribunals, and inquiries.
All right. So, dispute resolution, proceedings before court, tribunals, and inquiries. Imagine we have dispute. Dispute resolution could be anything with the Home Office. Dispute resolution could be anything with the tax office. Dispute resolution could be anything with your client, for your client on behalf of other bodies, court, and so on and so forth. And number one, it talks about we do not what misuse court time, right?
Mm-hmm.
Yeah, misuse or tamper with evidence. And that is one example. So if a client came to you to tell you specifically that something has happened and you know that this is in breach of 2.1, you will not entertain it.
Okay.
If you are aware, if you are not aware, different. But if you are aware, then that will be 2.1, isn't it? You do not
Yeah.
misuse, you do not tamper, and so on and so forth. And
Okay.
that is why sometimes you hear in the news that somebody did this, somebody did that, and that is tampering. And they say that in that case, we have breached our conduct. The next one is, please read the number two,
You do
2.2.
not seek to influence the substance of evidence, including generating false evidence or persuading witnesses to change their evidence.
So again, if you went before your solicitor and you told everything, of course, that is what you're supposed to do by way of instruction. Then
Mhm.
it becomes obvious that it may lead to something. Then of course you have to be able to say that sorry, this is what it is, and we have to stick to that. Even if it's not, if of course if it's not going to be in the best interest of that client, then you don't have to entertain and proceed at all. Because if by proceeding you are likely to do something which is not within the rules, and at the same time, because by doing it the client will be happy, by not doing it, the client will not be happy. But by doing it, you go against the rules. What is the best thing to do as a responsible solicitor? You have to decline, for example. So, can a solicitor decline? And these are the base, the context. So, we are setting
Mhm.
out the context so that when you go to your solicitor and you tell your story, and the solicitor says that on this occasion, I will not be able to take your case, you understand that the solicitor is operating within a guided rule.
Okay.
2.3. What does it say?
You do not provide or offer to provide any benefit to witnesses dependent upon the nature of their evidence or the outcome of the case.
All right. I mean, so here, especially when it comes to criminal proceedings or any other proceeding where you say, you know what, come and witness, be a witness, and this is going to be your reward. That will be against 2.3.
Okay.
Yeah. So if somebody came to you, he says that, oh, lawyer, you know what, whatever you can do for me, or whatever you can do to get somebody to help, of course, that would be tampering. I mean, no, that would be um, opening yourself up. Because if by so doing the person said that, oh, I can do anything for that person, then that is the person benefiting from as a result of giving the evidence or providing the account. And as a result of that, you are going to go against 2.3. Let's go to 2.4.
2.4 says that you only make assertions or put forward statements, representations, or submissions to the court or others which are properly arguable. And that's what you quoted for our nugget, isn't it?
Yeah, for our target. So here it could be going to court, it could be going to judicial review, it could be going, so appeal, administrative review, judicial reviews are all representations. It could
Mhm.
be that somebody whose um, leave has been curtailed, depending on the argument, you can also come under 2.4 if the argument is not properly arguable. Then, so these are some of the things that you as a solicitor will have to be mindful of and be able to say, yes, I will go ahead, or no, I decline to go ahead. So the question is, can a solicitor decline? The answer is yes. How? Why? These are the whys. How? We'll
Mhm.
come to how. Let's go to 5.
Yes, and 2.5 continues to say that you do not place yourself in contempt of court and you comply with court orders which place obligations on you.
And yeah, so that is for us solicitors. Um, this one, it has nothing to do with the declining or not. But once you accept, 2.5 is saying that You are so 2.5 is not one of the reasons for declining, but one of the reasons for making sure that you stick to court requests or directions or orders meticulously. So this one will not be relevant to today's conversation. Let's go to
Mm.
6.
You do not waste the court's time.
You do not waste court time. For example, a client comes to you and the client say, lawyer, I want to go to court for this. Or I
Mhm.
want to go judicial review for this. Question: if there is no arguable point in there, will that use court time or waste court time?
It will waste court's time because you can't properly argue that case. So the court will tell you, listen, you are here, you're wasting our time, go away. And
And
you know
between
the
the
consequences.
solicitor and the client, who should know better?
The solicitor should.
And so 2.6 will not be for the client. It will be for you, the solicitor, who accepted to represent and came to waste time. Because at the end of the day, we realized that if you had done the job properly, you wouldn't have wasted everybody's time bringing this quote unquote less um, meritorious case or argument before the court.
Mm. And the
And on
two
that
point,
basis, you can and on that basis, you can choose to tell the client that no, look, if I do this, I will waste court time, and that will go down against me. And so I'm sorry, I cannot go to court, or we cannot go to court.
okay. And
Next,
2.7 demands that you draw the court's attention to relevant cases and statutory provisions or procedural irregularities of which you are aware and which are likely to have a material effect on the outcome of the proceedings.
imagine you follow your client to court, and in the midst or somewhere within the proceedings, you discover a law that is against you and your client.
Mhm.
What will you do? Will you tell the court about it so that it is ruled against you, or you will hide from the court?
You'd have to declare that because if you hide from the court and they find out, then that's has dire
2.7.
consequences.
That's 2.7 against you, isn't it?
Mhm.
But if you tell the court too, that means you have accepted that you don't have a case.
Yeah. But it's
And that
better
is
for
why
you to protect your license and integrity as a solicitor than pleasing your client, isn't it?
And that is why you don't wait till midway, right from the beginning. You tell the client that I know about of a case that that's not that says that if this is the case, this is the outcome, and yours is similar or the same. And so, if that is the case, the court will become aware of this case because you have to cite the cases. And so, if
Mhm.
the cases you are going to cite will go against you, why then do you accept to follow the client in the first place?
Right.
And that is your reason to decline right from the beginning, right?
Hmm.
Or reason to decline during the process, even if it has gone midway and you become aware of certain new laws or new provisions that will go against the success of the case. You tell the court that this is it. And on that basis, we hands up, we can continue.
Right.
Right.
So
So
having done
yeah.
these ones, 2.1, 2.2, 2.3, 2.4, 2.5, 2.6, 2.7. These are the whys why you would want to decline representing your client. How do you tell them? Is it just saying it to their face, or you would have to quote some of these things and officially probably tell the client, listen, I can't do this. You booked an appointment. We have opened the file for you. We have assessed your situation and we realize that we can't represent you. So that's it. I tell you straight away. Or what do you do? How do you do that?
Yeah, two things. The initial stage, as I said, is the information you are aware of.
Hmm.
If the client came to you to say that, for example, I'm a skilled worker
Okay.
I came to the UK in 2023. Now, so the story, I came to the UK in 2023. I am a
Mhm.
skilled worker now, and I have switched to another skilled work visa now, and I want to continue with my family. On the whole, you would think that the person came to the UK as a skilled worker,
Mhm.
continues and still on it, and has switched now and want to add a
Mhm.
dependent. If the person came to the UK as a skilled worker in 2023, let's say, okay, the law allows those who were here before the law changed to continue with their dependents.
Right.
So that one is fine. But the missing point is that we didn't probe further to find out whether the 2023 the person was on the skilled worker visa or on a student visa or on some other visa.
Okay.
So let's assume that I thought that the person was on a student visa, was on a skilled worker visa, and so it continues. And at the time I'm about to submit the application, I assessed the evidence before me now, and I understood that, oh, hang on. I thought that you said you came as a skilled worker, but the information you've given me suggests that you became a skilled worker in 2025 and you have switched in 2026 to another
Yeah.
employer and you want to add your dependent because the visa the dependent were on is expiring. I've
Okay.
now become aware at the point we are submitting the application. Do I
Right.
have to continue or I have to decline? I have to decline. I have to say that, you know what, I think we got something wrong here. Granted that I didn't probe enough during the initial conversation. But
Mhm.
then, after you have submitted your evidence, it's obvious that you were not a skilled worker migrant before 11th of March 2024. And this type of skilled worker visa you are on does not permit dependent. And you want me to apply for your dependent. And on that basis, we cannot continue. Yes, the client may say it's too late. Why are you now telling me I'm at the verge of this? But it's better to let them know than going ahead knowing that the point you are going to make will not be arguable. And that will
Okay.
be in breach of 2.4. So you are not going to say in breach of 2.4, but you say that you know the law changed for you, for your dependent. And
Mhm.
so if I follow you to court, what am I going to, if I follow you to the home office, what am I going to tell them? Am I going to say that excuse me, my client is bringing an application, but my client is bringing an application as a dependent of a skilled worker, and I will quote the law. But the law I'm quoting is saying something else. So, what am
Mhm.
I doing if the law I'm quoting is undermining what I am doing?
We're going to put yeah.
Yeah. So, and even though it's at the last, or somebody will say last minute, but it's still better to tell them that unfortunately we cannot continue because of ABC. The application will not be successful, and what it means is that I will not be doing the right thing for you because your aim is to apply and to be granted. But if we are applying just to try and see what will happen, then that is not in your best interest. And on that basis, we cannot continue. Or if I'm going to do it, I have to argue on human rights. However, human right is not arguable for this type of application, and therefore
Mhm.
the law will not permit me to do so, especially representing you as a regulated lawyer, not a pocket lawyer. The person will understand.
Okay. So at the point that you realize that some facts are not in their favor, they may not have disclosed that to you from the beginning. When you find that out, you are obliged, in the interest of your status, integrity, and of course your license, you would have to declare to them that because of this new evidence or this new situation, we cannot continue. So you don't go and waste the court's time and you not go embarrass yourself in court.
Yes, that is what the rules require us to do. I'm sure if you do
Mhm.
that, the client will say, oh, wow, I know what you are saying is true, but I thought you could do it. But you are telling me the truth. There are instances where some clients will say, oh, lawyer, yeah, I mean, you've told me the truth. At least you've been honest with me that it's not just about my money, it's the best you want for me. And since it's not going to work, you cannot do it. And if I want to do it myself,
That's up to the client.
it's up to the client. So these are some of the things.
Okay.
So
So
these
in
are
this
some,
situation, what's how do you manage the client's expectation? Is it um let me put it bluntly this way. Are you going to refund their money?
well, refunding money is part of the process, but then two things. If it is your fault, you have to refund. If it is not your fault, then you cannot refund the money. Why do we say it's not your fault? It's not your fault when you have done everything right. But where it is your
Mhm.
fault, of course, it's only reasonable that you refund the money. So refund depends on the context.
In the context.
Refund
Okay.
depends on the context. But so the whole thing is this, that you are regulated and you are obliged to do the right thing. And so it's not
Hmm.
everything that comes to you from clients or from people that you have to accept and do. Where it is
Hmm.
not, um, where it will take you away from the remit of your obligation, you have to be bold and frank enough with the client to say that because of ABC, I will not be able to do so. I'm sure you've heard about instances where somebody will be complaining that, oh, the lawyer did it, and the lawyer said that it will work, only to turn out that the law has even changed, or it doesn't even make sense, or it doesn't work. I don't know whether
Hmm.
you've ever heard something like that.
Yeah.
Yeah, so at that point, the client feels disappointed, right?
Obviously, yes.
What it means is that if they knew about it, if you told them about this right from the beginning, they would have managed their expectation.
Right.
But because we are lawyers, whatever we say is taken to be the gospel. Because if we can't do it, we wouldn't have what? Agreed to
Taking up
do
the
it.
case.
But
Okay.
then there are instances where we may not be fully aware of the full facts. There are instances
Hmm.
where the law at the time will permit. And that is why it says that if the laws change, tell the authority concerned or the court concerned, even if it's going to go against you. So if the laws have changed and it's going to go against you, or you have become aware of certain fact or rule and it's going to go against your client, you tell the client. So there are instances where the case has started, but we tell the client that unfortunately because of A, B, C, D, we cannot continue to act in your matter. Then
Okay.
you have to explain to them why, but it has to be clear so that you manage the expectation as well. So it's just like saying that we we have a right for everything, but
Hmm.
not everything is lawful for us to do. That is what it's all about.
Yeah. So if you just joined us, ladies and gentlemen, we are on the program, The Community and the Law, and our resource person, lawyer Charles Asma, is helping us go through the expectation that you have and how it's managed. If it is that they have every reason to believe that your case is not going to be properly arguable, the situations and the conditions around will not make you succeed. They have the obligation to let you know and then tell you that either we can continue or we have to follow a different pathway. That's the responsibility of a lawyer. So, the question we are asking, can a solicitor refuse to take your case? The answer, from what lawyer Charles Asma has told us, is yes. And they will tell you what it is that you need to know. I know you have some questions. I know you would want to give a try to the situation we gave you. Get yourselves ready. After this break, we'll come into that. And then we will get Lawyer Asma to conclude for us and then re emphasize the point that yes, they can refuse. He's told us how, and he's told us the why. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, you're live with us on BWTV, and the program is The Community and the Law. Can a solicitor decline to take up the case of a client and say, I can't represent you? The answer is yes. How? We've been taking through that. If you have any question, drop that in the comment section down below at BWF Solicitors and at BWTV, both on Facebook and YouTube. And of course, you can send a text to 07399208468, and we'll pick that up and get Lawyer Asma to help us. And also remember, I gave you a scenario where Hafiz had a situation, and we asking, or the solicitor is asking for our advice based on the knowledge we have had this afternoon. So let's take some questions and we'll come to that as well. Acosti the Boss 145. My brother on a partner route visa now, but he came to the UK in 2021 on a student visa. After school, he then moved on to the graduate route. He then moved on to the spousal visa. Can he apply for indefinite leave to remain now? I think the start point is 2021, lawyer.
So please help me.
Yeah, so the partner, the brother is on a partner route visa.
The brother is on a partner route, yes.
Yes, and he came to the UK in 2021 on a student visa. After school, he moved on to the graduate route. Then he's moved on to the spousal visa route. Can he apply for indefinite leave to remain now? That's why I said the start point probably from him is the 2021 bit.
Right. So what we say is that because he switched to the partner route, the final point will be the partner route, and therefore the 5 years on the partner route will be the standard.
Oh, okay. He actually hasn't told us when he switched onto the partner route. So, for instance, if he switched onto the partner route, say in 2024, it will be 5 years from 2024.
So 5 years, because a partner rate is 2.5, 2.5. So
Mhm.
5 years. Yeah.
From 2024 when he switched onto that route.
When he switched, yes.
Okay.
Because
All right.
graduate route doesn't qualify that doesn't lead to indefinite.
Okay.
Yeah. So the partner route, I don't know whether British partner or skilled worker partner, but that will be the starting point.
Right. So yeah, Acosti, the boss, thank you very much for your question. We'll move on to the next one. My name is Stella. I'm on a graduate visa which will expire next year, July. I've met a British guy who intends to marry me, but thinks he does not meet the requirements. I'll be happy to speak to you and see the way forward. I would want to put it in or situate it in the context of our discussion this afternoon. Would you take such a case?
Sorry. Let's take it again, please.
Yeah, this person is saying that they are on the graduate visa route, and the graduate visa will expire July next year. This person says they've met a British guy who intends to marry them, but thinks he does. The British guy thinks he does not meet the requirement. And this person is saying that they are happy to speak to you and see the way forward. Then I situated in our discussion this afternoon. Would you take this case?
Yeah, so I mean that is what we do.
Hmm.
We are supposed to give advice within we take the fact and the rule. The person is
Okay.
saying that I think I qualify, but I'm not sure. So I need a lawyer to speak to me. So once the
Hmm.
person comes, we'll look at their profile, gauge against the rule under Appendix FN, and say that you meet the financial requirement, you meet the relationship requirement, and also the relationship under paragraph RWP 6.1, 6.2, which is genuine and subsistent relationship. You meet English language and you meet the immigration status requirement because you have a visa which is not expired and can be switched. If that's the case, they qualify, they can do it. That is what we are supposed to do, offering advice within the rules. If it is not
Okay.
going to work, you say that unfortunately your partner, unfortunately you don't have visa, you don't work and you earn 29,000, so you will not qualify under 5 year route. There's no child, so you can't get under 10 year route. Your partner is not sick for you to say that you have to be here to look after your partner. Therefore
Hmm.
the application does not meet the requirement under paragraph ELTRP 1.1 or Gen 3.1, 3.2 or paragraph EX1B of Appendix FM, and so it will not work. You have to be bold and clear with the client. So when the person comes, that is the advice we'll give.
You give. Right. Thank you very much, lawyer. We'll move on to the next one. Keep them coming through. You can send a text to 073 992 or you can leave them in the comment section below as people are doing. This one comes in and says Larry lives with his wife in a one-bedroom home with their 1 year, 8 month old child and their newborn baby. Is it allowed for them to continue living in a one-bedroom home as a family in the UK? The husband, the wife, they have a 1 year, 8 month old baby, and they have had a new baby as well. So now there are four people in the family living in a one-bedroom home. Is it allowed?
Well, that's not enough. How? Yeah, because the mother and the newborn can be in one room, but the other kids cannot, depending on their ages. And is there adults? How many adults are there?
So the husband, the wife,
So
um,
husband and wife will be one. Then
mhm.
two. How many children?
We have a 20-month-old baby
Yeah.
and a new one.
Okay. So the 20-month baby and the new one can be in another room. So if they have one bedroom and a hall,
Okay,
then they can. It's fine.
right. One bedroom and a hall or lounge should be fine.
Yeah.
Okay, All right. Thank you very much, Larry. That's your whoever brought it. That's your thing. I am on a skilled worker visa, lawyer. I came to the UK in 2022, and my wife joined me as a dependent in 2024. I will be eligible to apply for indefinite leave to remain in 2027. However, by then my wife will not have completed 5 years in the UK. What visa would she be on after I get my indefinite leave to remain? Can she continue on her dependent visa until she becomes eligible for indefinite leave to remain?
Yeah, Brakoku, let's take the key facts, please.
Mhm.
So the
Okay.
key facts.
Well, it says it came. She's on the person is on a skilled worker visa. Came to the UK in 2022.
Yeah.
The wife joined him as his dependent in 2024.
Okay.
Now he's saying that he will be eligible to apply for indefinite leave to remain in 2027.
Okay.
However, by then the wife would not have completed 5 years in the UK because the wife joined in 2024, 2 years
So
after he had
so the
come to
person
the
is
UK.
worried about the wife.
Yes.
Oh, it doesn't matter. Even if the wife has spent 1 day in the UK, when he is applying for indefinite, he will have to apply together as a family.
Okay.
Yeah, so that should be fine.
Right. Thank you very much for whoever brought this one in.
Thank you
You
so
didn't
much.
add your name, but it's fine. Obviously, your question would be of benefit to another person. Emmanuel Young says, "Can you switch immediately when your sponsorship license is revoked, but you haven't received any email from the Home Office?"
But a quick question again.
Can you switch immediately when your sponsorship license is revoked, but you haven't received any email from the Home Office? Well, keep them coming through. You can send us a text on 07399208468. If you want to get in touch with BWF Solicitors, you can call them on 0208 493 7340. Remember, BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. Call them, as I mentioned earlier, on 0208 493 7340 or 077 127 61884. 077 127 61884. We have Lawyer Charles Asma with us as our resource person for this afternoon. We've looked at a situation where the solicitor would say, "I am declining to take your case because of X, Y, and Z." He's taking us through how they do that, why they do that, and of course, he's now answering our questions. Lawyer, we are asking the question that can you switch immediately when your sponsorship license is revoked, but you haven't received any email from the Home Office?
Right. I mean, so the rules are that once the sponsor's license is revoked, the the Home Office must give you notice, 60 days notice.
Hmm.
And even when you are in that 60 days notice, you can switch.
Okay.
So if you haven't received the notice, you can switch. When you receive the notice, you can still switch, but you have to make sure you apply or switch to something else before the 60 days notice is up.
Okay. Right. Thank you very much. We'll pick up the next. There was this conversation I chanced into. When I finish with this one, I will put it before you. It's a very interesting scenario. Witty Blissful comes in and says, a friend has overstayed. Lawyer, he met a lady who is an EU national with kids. They've done their proxy marriage, and the friend does his role as a stepfather. One, what documents does he need to put into an application? I would ask, what kind of application are you putting in? because obviously you don't have any status, so you want to apply based on your EU lady and their kids. Okay. Two, does the lady has to prove a threshold of 29,000, else they are exposing themselves to the Home Office?
Okay, I mean, all that this person is asking is they are married and the wife has children who are potentially qualifying children because the children are EU nationals with 5 years or with indefinite. The man lives with the wife, they are married. And so this man has become a stepdad to the children. If the
Mm-hmm.
man can prove that he's in the life of the children, looks after the children, there's letter from school GP and the lady herself to prove it, then yes, he can apply. He doesn't have to show 29,000 because the application is not coming under the spouse. The application is coming under the children as a parent, and therefore the person must meet the eligibility requirement under paragraph ELTR PT 1.1 of Appendix FM to the immigration rules. And because the person doesn't meet the 5-year requirement, the application will be made under paragraph EX1A of Appendix FM, which says that if you don't meet some of the requirements, your application can be considered because of the interest of the child within this family unit. And so, Section 55 of the Borders Act 2009 will also be activated. And by and large, the person will be considered with 2.5 years visa under the 10-year route, not because they are married, the person is married to this woman, but that the person is married to the woman who has children, and so the man has become a stepdad, playing active role in the life of the children, and so the application will also come under Section 117B, subsection 6 of the Nationality, Immigration and Asylum Act of 2002. So the person is asking what sort of application you apply as a parent under using form FLRFP online form. You have to show that this you are married, so marriage certificate. You have to show that the children are for this woman, birth certificate. You have to show that the children have EU passport with um, leave to remain in the UK, and you have to show that you play a role in the life of the children, and so the children need you in the UK. That is all you need, and of course, just suitable accommodation for your shelter purposes.
Right, lawyer. Thank you for that. There's an interesting scenario. I chanced onto that conversation, and I want to throw it in here before we go on to Nugget and the scenario. This person says that out of the blue, the partner with which they are on the same skilled worker route has produced a document to say that this person that was narrating their situation has gone to Ghana and filed for divorce. So they have been served. And this person is saying, well, I don't know about that. You are saying I filed for divorce. I have not. How does this person contest the situation?
Is it situation of the divorce or situation of fraud?
The situation of the divorce, because this person has not filed divorce, but now he's being given a document to say that this person was a plaintiff. The person knows nothing about it. How do they fight or correct the situation? Because
I mean,
obviously it's forged.
if the divorce is not valid, they can only reopen the case.
Okay. All right. It sounds very interesting and funny, but I'll leave it there. Um, Let me quickly go to the scenario we had, lawyer, with your permission. This case about Hafiz and the situation he presented to the solicitor. So Hafiz joined his partner in the UK in 2023 as a dependent of a student. His partner completed her studies in December 2023 and he switched with her to a post-study work visa in January 2024. Before the post-study work visa expired in 2026 January, he and his partner applied to switch to a skilled worker visa under occupation code 6136 for senior carers. A month later, his partner's visa was granted, but he was refused. The reason was that he does not meet the requirements for a skilled worker dependent visa as the rules had changed. He immediately applied for administrative review, which was decided on the 20th of June 2026 to maintain the refusal decision. Now, he wants the solicitor to challenge the refusal decision at a judicial review. So, what can we tell the solicitor? That he should accept the case and challenge on human right grounds for Hafiz, as that is his only chance. Are we going to tell the solicitor that he should not accept the case because any argument will not properly will not be properly arguable, and thus will be a breach of the conduct rule? Or there's no hope for Hafiz. There's none of the above that the lawyer can do. Um, well, I've given you this earlier, so I would say to bring up your answers. Patience Boating says none of the above. The next one is coming from Jessica Yema, and Jessica says the solicitor should accept the case and challenge on human grounds, human rights grounds, I should say. Angie thinks the same, that it should be number one. Lydia Forsing thinks
Yeah.
it's none of the above. And I'll take just one more because of time. Oliver Imchi says is number two. The solicitor should not accept the case because any argument would not be properly arguable and thus will be in breach of the conduct rule. Lawyer.
Right. So we check the conduct rule. What
Mm-hmm.
does the conduct rule say? It says that paragraph 2.4 of the conduct rule says that if the case is not arguable, don't accept it. Now, this person made application, did not qualify. The person was refused genuinely, and the person wants to fight it. Why will you fight a losing battle? And why will a responsible solicitor follow somebody to fight a losing battle? That will be taking a case that is not properly arguable. That means you are not acting in the best interest of that person. And so the solicitor should not accept the case. Otherwise, the solicitor will be doing what is not within the rules. Even though they can try it, but it is not acceptable behavior of trying anyhow. Because a good solicitor don't do try and see. There are instances where you go by try and see. There are instances where it's so obvious that try and see will not work.
No
And
word.
so you don't have to entertain it. The answer is that the solicitor should not accept. Number two.
The answer is number two, should not accept the case because any argument would not be properly arguable. We're talking about paragraph 2.4 of Solicitors Regulation Authority Code of Conduct for Solicitors. Lawyer took us through that. And then for that, and I would say, maybe now I'm in the classroom, so under my tutorial rules. In a minute, what did you take us through this afternoon, lawyer?
Thank you. In a nutshell, we looked at what solicitors must do, whether to accept or decline a case once clients come to us, or even in the middle of that case. If it's necessary to decline, we have to be bold to say, no, we can't continue. So when a client comes to you, we listen to the case, we listen to the story, we assess against the rules. And where the rules allow for us to continue, we'll continue. Where the rules do not allow for us to continue, we do not have to continue. And so, where you don't have to continue and you continue, you will not be acting in the best interest of the client because nothing will happen for the client. And also, you may be accepting to do something that defeats reasonableness and common sense. And so, it's always important that for us as solicitors, we do that. And for you as clients or members of the public to accept that It's not everything that a good lawyer must accept to do. Even though that will make you happy, the happiness will only last in a moment and you'll be crying the next moment. That is why we have to decline when we have to decline. And when we do decline, I explain to you why we are required to do so per the ethos of our profession and per the principles that we have to uphold. Thank you.
Thank you very much, Lawyer Charles Asma. So, viewers and the community, let's appreciate Lawyer Charles Asma for his time and also making the effort to help us through all our situations when it comes to the law. And to BWF solicitors, let's also say thank you with of our hearts to you for allowing us to run this platform for the benefit of the community. Remember earlier on, we mentioned that there have been some updates, and I want you to really appreciate those updates. First, major UK reform family life claims are going to be having some tougher rules around it, and the government has introduced the Border Security, Asylum and Immigration Bill, proposing significant changes to how family life is considered in immigration cases. So they're talking about the Article 8 of the European Convention on Human Rights. Though has not been abolished, they are saying that more weight will be given to the public good than the person's human right. That's one of the updates. Another one is some introductions that will be done in 2027. Life in the UK test is moving towards a greater focus on British values, democracy, civic responsibility, and integration. Then higher English language requirement is starting from the 26th of March 2027. So instead of level B2, instead of level B1, sorry, they are replacing it with level B2. So if you are eligible for settlement, consider applying before the higher English language requirement takes effect. If you're preparing for the Life in the UK test, continue studying the current test until the Home Office formally introduces any other changes. Then the character bit was also giving us, and the Home Office is saying that they have significantly tightened the good character requirement. A past illegal entry or even overstaying could now result in your citizenship application being refused, despite having settled status or indefinite leave to remain. So the advice here is that before submitting an application, make sure you understand how your immigration history could affect your eligibility. The Nationality Act and the good character requirement that was updated on the 30th of April 2026 is what we have referred to. And again, join me in congratulating our very own Pamela Oakley for winning the Employee of the Month, June 2026. Congratulations to you. And on that note, I want to say thank you to the BWF Solicitors family, from the senior partner to the very last person in the room. And if you want to contact BWF Solicitors, you call 0208 493 7340, or in emergency situation 077 127 61884. You can visit the website www.bwfsolicitors.com. There are a lot of resources there that can help you understand all the situations that we update you on, or you can visit them on their social media platforms at BWF Solicitors. I worked with Felicia. Sorry, your review I nearly missed. Let me quickly put that as part of the appreciation we're showing to BWF Solicitors. And Felicia, you said you want to thank BWF Solicitors for the excellent service and outstanding support. Special thanks to Lawyer Emmanuel for his professionalism, patience, and dedication throughout the process. You and their family are very grateful for everything you did to help obtain your visas. You will highly recommend BWF Solicitors. Thank you, Felicia. Sorry, I nearly missed that. But yeah, a stitch in time says nine. And once we have remembered, in the Ghanaian language, you say Sankofa Yenchi. It's better to go back for it than to leave it out altogether. Padwadodu Shilankra and my producer, Professor Ade, have supported me. My name is Oreku Fimpon. Have a good evening.